And some practices will even have their own separate buy-sell agreement established. And that is probably the best way to go about the buy-sell agreements, is to have a separate document that details what happens to the practice shares if one of the owners passes away, if one of the owners gets sick or hurt and becomes permanently disabled, or what if they declare bankruptcy. That usually will trigger a buy-sell agreement, or if there is a divorce, that will sometimes trigger a buy-sell agreement. You're listening to the MAdvisor podcast. I'm Paul Morton. MAdvisor helps physicians with their financial planning. This podcast is intended to provoke insight into your finances so you can learn, plan, and create a legacy you're proud of. Discussions in this show should not be construed as specific recommendations or investment advice. Always consult with your investment professional before making important investment decisions. Securities offered through Cambridge Investment Research, Inc., a broker-dealer, member FINRA SIPC. Advisory services offered through Cambridge Investment Research Advisors, Inc., a registered investment advisor. Cambridge and MAdvisor are not affiliated. Welcome to the MAdvisor podcast. I'm Paul Morton. The MAdvisor podcast comes out on payday, the 15th and 30th of each month. Today we're talking about buy-sell agreements. A buy-sell agreement is basically a document that states what happens to someone's business interest in the event of a death, a disability, a divorce, a bankruptcy, etc. So for a physician that owns their own practice or works in a private practice, a lot of times you have a buy-sell agreement and you don't know it. Usually it's the death portion, what happens to your share of your practice when you pass away. That is usually embedded in either an operating agreement. It could be embedded in a corporate shareholders agreement. It could be in its own separate buy-sell agreement. If you bought into a practice, like you didn't start it from scratch, you bought in, there's typically going to be an agreement or a statement or some sort of operating policy that states what happens to your business shares, what happens to your ownership if you pass away. Somebody may be forced to buy that particular piece of ownership. If someone in your practice passes away, you may be that somebody who's forced to buy ownership. The best way to know is to request a copy of the operating agreement or the corporate shareholders agreement, some sort of operating policy that shows you the inner workings of the business and the shares of the business. And some practices will even have their own separate buy-sell agreement established. And that is probably the best way to go about the buy-sell agreements, is to have a separate document that details what happens to the practice shares if one of the owners passes away, if one of the owners gets sick or hurt and becomes permanently disabled, or what if they declare bankruptcy. That usually will trigger a buy-sell agreement, or if there is a divorce, that will sometimes trigger a buy-sell agreement. And the reasons the bankruptcy and the divorce protocols are included in some of the buy-sell agreements is that for the bankruptcy proceedings, the business shares are oftentimes included in personal assets for liquidation for bankruptcy courts. And then sometimes in a divorce case, depending on the state and depending on the situation, there can be situations where the shares of the business can be redirected to an ex-spouse. So then there is a change of ownership. So usually whenever there is a change of ownership is when the buy-sell agreement kicks into play. So somebody dies, there's a change of ownership. Somebody gets sick or hurt and they can't come back to work again, there is a change of ownership. If ownership is passed to creditors or ownership is passed to a spouse, that is a change of ownership. How do these buy-sell agreements work? In these operating agreements or in these buy-sell agreements, they will detail what happens. Does the business purchase the shares of the, let's call it the deceased owner, or does the partner or partners have to purchase the shares of the deceased owners? And then how do they purchase the shares? Is it by using operating capital? Do they go get loans? Or are these particular plans insured? And having an agreement established like this will allow the owners to discuss how they want to fund it. And it doesn't have to be a binary all or nothing type of funding. Some partners might insure like a certain majority percentage of the shares and the remainder maybe use operating capital or maybe even loans or have a line of credit available. But usually when a buy-sell agreement is established, especially as a separate agreement, there's usually an insurance policy that would be purchased on all of the owners. And there's two forms of this particular buy-sell agreement. They are called cross-purchase buy-sell agreements and entity purchase buy-sell agreements. How the cross-purchase works is it works best when there's just two owners. So each owner would just buy one insurance policy on the other. Then they would own the insurance policy. So I would own the insurance policy on a partner and the partner would own one on me. That way, if I die, the proceeds go to my business partner and then my business partner buys my shares, and then wherever I had designated my estate planning to go to, it might go to the trust, whatever the buyout would be if I have established an estate plan, and then that ultimately would go to my family. So then it would almost be like buying a life insurance policy for my family, except they get the cash and they don't have to deal with the business, and then the business partners don't have to deal with a new owner who may not be familiar with the inner workings of the business. To some degree, that is a pretty solid win-win situation where the cross purchases work beautifully, again, as in those smaller companies. Let's say 2 to 3 individuals. If there are 2 individuals, there's 2 life insurance policies that are purchased. If there are 3 individuals, there are 6 life insurance policies purchased because each partner of the 3 has to own 2 policies, 1 in each partner, and that happens 3 times. If there are 4 partners, there are 12 life insurance policies to be purchased. And it goes on and on, 20 policies for 5 partners, 30 policies for 6, and so on. So it can get pretty crazy just to manage some of the life insurance policies in a cross-purchase buy-sell agreement when there are more partners than maybe just 2. The advantage of having the cross-purchase agreement, 1 is its simplicity, but then 2, it actually will increase the owner's basis. The owner who is buying out the deceased partner, they will then own 100% of the business. And that ultimately is a good thing, especially when they go to sell the business, then they have that much more basis to shield against things like capital gains taxes. With the cross-purchase arrangement, it is simple until it's not, and it becomes unsimple when there are more owners. The other type of buy-sell agreement is called an entity purchase. So this is basically where the corporation or the business would own a policy on each business owner. So then if there are 6 business owners, there are 6 policies. The corporation owns all 6 policies. And it's way, way easier to manage. So it's a lot simpler with a lot more owners. But what happens is the business is who buys out the owner. So if there are 6 owners, one dies, the business buys out the owner, and there's 1/6 owner shares that are owned by the business, and then 5/6 shares owned by the individuals. So the individuals still have the same basis in the company. They still have 1/6 voting rights, but there are 6 votes and 5 individuals. And so over a long enough period of time, that needs to be figured out on how that ownership's distributed, if it's distributed, and it can't just be gifted or given away. So usually there would be some sort of buy-in for that particular owner's share. With that buy-in, it would increase the owner's basis, the remaining surviving owners. It would increase their cost basis, but that would have to be discussed and figured out essentially ahead of time. It would be really difficult to figure that out after the fact, although probably not impossible. There are some of these mega practices with 15, 20 physician owners, a lot of physicians that have bought into the practice, and it's all physician owned. And some of these will have these buy-sell agreements embedded in them, but they either aren't communicated, they're not discussed, they're not known. Almost anyone who has a shareholders agreement hasn't read their shareholders agreement yet. So that is usually step number 1, is read the shareholders agreement or the operating agreement and see what it says. What are you responsible for? What are you on the hook for? Because when that does occur, when someone in the practice, when an owner dies, especially if it's like a majority owner, there's usually lots of surprises with how that business interest will be handled and how that interest will be distributed to the business or to the other owners and partners. And that's just not usually a surprise that's fun to deal with. There's usually a lot of learning of what you have to do and what you're responsible for. Essentially, after the fact, you're responsible for doing those things. So if you own a practice, if you are working at a practice that has buy-in opportunity, either when you buy in, before you buy in, or right after you buy in, that's one document, that shareholders agreement or the operating agreement. And also if there's a separate buy-sell agreement, those are things that you want to have copies of. And if there's no such agreement on file, which sometimes that is the case, then that's also something to discuss. Because if you don't like your partner's spouse, or if you don't know your partner's spouse, then that might be your next business partner, like it or not. If something happens to your business partner, they pass away, and then do their shares pass on to their spouse and to their kids? And so these are some of the questions that you are trying to answer and get clarification on when researching the shareholders agreement, operating agreement, and buy-sell agreement. And even though it is probably unlikely that not one of these things exist, if none of these exist in an established practice, that is surprising. But if that is the case, then it might also make sense to suggest establishing these types of documents. Thank you for listening. I'm Paul Morton with M-Advisor. M-Advisor helps physicians with their financial planning. You can visit m-advisor.com for more information. And I appreciate you listening and being here today. This is the M-Advisor podcast.